So hi guys, welcome to our latest webinar around the Employment Rights Bill and the Umbrella legislation. My name's Chris Fahey and I'm the owner of AGPayroll. So I'll give you a bit of background on who I am and a bit of where I've came from. It's a bit of an unusual story, as I don't think there's many other payroll company owners that have had the sort of background that I have. I started out when I was 18 as a professional footballer. You'll see here in the old black and white photograph here, I started out full time with my boyhood heroes, Celtic. That's me with the goalkeeper in the middle there with the dodgy middle shed. So yeah, at the time I was living a dream, signed for Celtic. I was the Scotland under 18s goalkeeper. And then like 99% of most young footballers at that age, I get called into the office at the end of the season and get hit with a sledgehammer and get told that I was getting released. So my world was turned upside down, didn't know what I was going to do. So I decided to go back to university, went back, got my business degree, and then by the time I was 21, came out of university. And I got the offer to go back into football at a lot lower standard than Celtic. I went and signed full time with a team called Albion Rovers. So I was sort of bottom left there, a young 21-year-old there. But I played football full time. And then the manager at the time was a guy called John McVeigh, proper old school manager. I told him I had this business degree and I didn't want to waste it, if you like. And he offered me the job in the afternoon as the commercial manager. So at 21, I was the commercial manager at Albion Rovers, the youngest ever commercial manager in Scottish football history, which sounds great and sounds glamorous. But if you've ever seen Clifton Hill, the club's been around for 140 years, and the stadium I don't think's changed in 140 years. So it was quite a tough shift trying to sell the advertising and the hospitality, etc., for a small club like Albion Rovers. But I did that for 4 years as well as playing football, and it was great. It gave me a really good grounding into sales. I had to go around the sort of pubs and clubs in Coatbridge and try and sell the advertising, hospitality, etc. So yeah, that gave me my sort of grounding into business, if you like. When I was 25, I realised I wasn't going to be the next Peter Schmeichel. So I went from being full time to being part time at the football, and then that's when I got into the payroll industry where I've been for the last sort of 20 odd years. But I did carry on playing football part time. Played for some sort of lower League One and League Two teams: Albion Rovers, Wraith Rovers, Stranraer, Clyde. So I played lower league football for around 20 years, so I got the sort of best of both worlds. So now I'm now the owner, as I said, of AG Payroll, and we've been up and running now for over 2.5 years. And a couple of weeks ago, we went down to London and we were over the moon to win the Contracting Awards Umbrella Company of the Year, which was a massive award for us, myself and the team, and what we've built at AG Payroll. We've built everything around sort of service, compliance, and technology. So to go and win that on a sort of a grand scale like that was just sort of reward for everyone. So yeah, we were absolutely buzzing. We were over the moon with that. So as a company, we offer the two main services we offer are umbrella payroll and CIS payroll services. But we have got some other services we offer like bureau. We can do compliance training. We can also partner with companies and payroll in over 160 countries globally. And I'll touch on it a bit more later, but we can do umbrella legislation audits now as well. So that's just a wee bit of an overview of who we are and what we do. So as I touched on there, that one of the main things I wanted to do when I started this company, my background in payroll was I worked with some of the biggest payroll companies in the market, the big sort of compliant payroll companies. But I've seen what good looks like, but I've also seen what bad looks like. So I wanted to make sure that we were 100% compliant because I knew that the consequences of not being compliant just weren't worth the risk. Nobody wants HMRC on their case, so I've got a wife and three kids, and I quite like sleeping at night, so I wanted to make sure right from day one that we got things right and we done things 100% compliant. The very first thing I did as a payroll company owner of AGPayroll was get my safe rate accreditation. It took us 9 months to get there, but it made sure that everything that I did was fully compliant and that all the taxes were paid to HMRC on time. So it could not just give me, it could give my agencies and also their clients that peace of mind. So we've picked up a few other badges of honour along the way. We've got pre-term resources accreditation. Our payroll software is HMRC approved, and we're just on the brink, don't want to jinx it, of getting our FCSA accreditation. So once that happens, we'll be one of the only payroll companies in the UK that will have the two biggest accreditations, which costs a lot of money and there's a lot of time and sweat and due diligence that has to be done to get these badges of honour, if you like, but well worth it, especially with what we're going to discuss on here coming up. So first thing we're going to talk about is the UK Employment Rights Bill. So this bill, it represents a landmark of overhaul in the UK employment law. It's looking to strengthen workers' protections and modernise employment practices. So basically, they're looking to give temporary workers and contractor workers the same rights as permanent employees. The Labour government has always been on the side of workers and trying to give the workers rights. There's always been fairly unionised Labour. So this is a part of what they'd said. Again, I'm not political here. I don't like any of the political parties. I think they're all as bad as each other. But this is one of the things that they did promise to bring into play was the UK Employment Rights Bill to make sure that they give contractors and temps more rights. So this will be phased in over the next couple of years. So the reason Labour have looked at this, there's three sort of fairly big cases that have came into play over the last maybe 25 years. So there was the Uber drivers case where the drivers were on 0-hour contracts, and also the Deliveroo drivers where they were on 0-hour contracts. So these contractors were effectively doing everything that a full-time employee was doing, but they didn't have any of the rights. And these went to court, and the court went down the route of upholding what Uber and Deliveroo were doing. So they were saying that 0-hour contracts, although it was a bit of a grey area, it wasn't uncompliant. So again, that was something that Labour looked at, they weren't happy with, and they wanted to change that when they came into power. And probably the biggest case was the P&O ferry dismissals. So there was 800 P&O employees dismissed. The company were 100 million in debt, and they decided to let go 800 staff. They then brought on 800 contractors or temps, and they brought them on at a lot less rate than what the permanent employees were getting. And some of these contractors or temps were getting less than minimum wage. Some of them were getting as little as £9.50 an hour. Again, that was something that there was no legislation or law that could punish them at the time. So something that Labour said, right, when we get into power, we're going to do something about that. And hence why we now have the Employment Rights Bill getting brought in over the next 2 years. So what are the key changes that they're going to bring into play? So starting from next year, as I said, these will be phased in. So there'll be the temporary workers or the contractors will then have day one rights. So they will now receive core protections such as sick pay and unfair dismissal rights right from day one on the job, which is a change from where we work at the moment. Flexible working will be as a default. So if someone wants to work from home, you can't just say you can't work from home. Under the new legislation, you have to give a reason why they have to come in the office. If they have a viable reason where they have to work from home, you have to accommodate that. If you can't accommodate that, then it has to be documented as to why you can't do that. You can't bring that into play. So that's one of the things they're looking at there. 0-hour contracts it's just basically 0-hour contracts are going to be a no-no. I don't think that happens as much these days. But if you do deal with zero-hour contracts, or you know anyone that does, then just stop it as of today, because that's going to be a complete no-no come next year. There'll be a ban on the fire and rehire practices. Again, it goes back to my P&O example earlier on, so that will be illegal as of next year. And statutory sick pay will now start from day one of sickness, and it will be capped at either 80% of the salary or 118.75 per week, whichever is the lower. The tribunals, there'll be an extended time limit on that. At the moment, there's a 3-month limit when you leave your role to be able to put a claim in. That'll be extended to 6 months. We've been told by some employment law lawyers that this is going to just put these cases through the roof over the next couple of years. So no doubt the courts will be inundated with claims. But yeah, they're going to extend that up to 6 months to be able to put a claim in. And all of this is going to be overseen by the government is putting a new body in place called the New Fair Work Agency. And they're going to be ensuring that these rights are put into play. So they'll be auditing companies, agencies, payroll companies, whoever it may be, to ensure that everyone's fully compliant with the new changes. So the timeline on this, apologies if you can hear the fire alarm going off, I'm hoping it's just a test here. The Employment Rights Bill timeline, they introduced this, or they said they were going to start doing this as of April 2025. The bill passed through the House of Lords and was debated then, and it will be given royal assent by the end of 2025. So we're thinking that will be finalised in the next few weeks, and it will now be known as, instead of being the Employment Rights Bill, it will be known as the Employment Rights Act once it's given royal assent. So the timeline on that, and it starts to be phased in from April 2026. So the new Fair Work Agency, the government body, will be brought into play to make sure they oversee this. There's going to be over 5,000 staff in that department. So they're throwing some money at this to make sure that everything is fully compliant, that people are doing things correctly. The implementation of day one rights for paternity leave and unpaid paternity leave will come into play then, and the day one statutory sick pay rights will come in then. October 2026, then the ban on fire and rehire tactics will come in, and the introduction of a new employer duty to prevent sexual harassment and new protection against harassment by third parties will come into play, as well as the extension of the employment tribunal claims from 3 months to 6 months. And then in 2027, there'll be the day one unfair dismissal rights take effect. The 0-hour contracts will be cracked down on, and there'll be compulsory equality action plans for some employers. So that's a bit of a timeline on where we're looking at. So what does this mean for agencies? So ultimately, there's going to be more compliance, higher compliance expectations for every placement. So the agencies have to make sure they are organised. Contracts will have to be reviewed. So I spoke to an employment lawyer about this, and effectively your contract should be audited by whoever looks at your contracts to ensure that they mention the Employment Rights Act. If they don't mention the Employment Rights Act and all the different things that we've touched on there, then that's a massive red flag to HMRC or to the Fair Work Agency, who may come in and audit you at any time on this. So make sure your contracts are all reviewed, your contracts between you and your client, and also your contracts between you and your contractors as well. So make sure everything is reviewed and it mentions the Employment Rights Act there. Manager training is essential. Again, just bring your teams up to speed on what's happening and what's coming ahead. It will be finalising everything in the next few weeks once this gets the royal assent. So as soon as we know everything is finalised, then bring your team up to speed on that. And there's going to be higher tribunal risks. The fact that they're extending the time limit to 6 months means that some contractors are going to be aware of that, and they're going to start putting more claims in. So just make sure you're ahead of the game by making sure your policies, your processes, and your contracts are all up to speed to cover the upcoming legislation changes. So yeah, the One of the big changes that's coming in next year is the new umbrella legislation. I actually think this is the biggest change in my 20 odd years in the industry, because it's a potential game changer, business ending for agencies. So agencies have to ensure, if you partner with a payroll company or an umbrella company, you have to make sure they are fully accredited and they tick all the boxes from a compliance point of view. If you don't and you cut any corners, then the consequences are huge. Under the new legislation, the legislation states that there will be joint and several liability. So this means that just now, the way it sits, the agency, the umbrella company is liable for any unpaid taxes. In the new world, that liability will sit with the umbrella company, but also with the agency. So if the umbrella company goes bust, then it's the agency that is on the hook for any unpaid taxes. So if you're in partnership with an uncompliant umbrella company and they go bust, then you're going to be the one that's hit with a bill. And the amount of money involved here, it could be business ending. There'll be loads of tips in here of what you need to do to make sure you're fully compliant on it. That gives you an idea of how many temps or contractors are paid through umbrella companies. There's 700,000 plus temps or contractors paid through umbrella companies at the moment, and there's 300,000 temps or contractors paid agency PAYE at the moment. So around about 1 million temps or contractors that this brings into play. So HMRC, quite rightly, want to make sure that they are receiving all their PAYE tax and NICs for these workers. So these changes are coming in. At the moment, AGPayroll, we are 100% compliant with this. So if the legislation came in today, we would be good to go with it. So we welcome the changes on this. Effectively, what legislation is going to do, it's going to separate. The good guys will be fine. So the compliant payroll companies will be okay. They'll just carry on as normal. The non-compliant payroll companies will be the ones that will be hopefully run out of town. Then the good compliant payroll companies it'll be a level playing field for everybody. So, as I said at the top there'll be joint liability on any unpaid taxes for the agency if you use a non-compliant payroll company. Even though it's called the umbrella legislation, if there's not an umbrella company in the chain and it is the agency and the end client, then if you pay your workers PAYE and there's an agency, there's a client involved in this, then there still has to be two parties that are joint and several liable for any unpaid taxes. So in that scenario, it will be the agency and the end client that are liable for any unpaid taxes. Now, what we're actually finding now is that a lot of the clients are now aware that this legislation is coming in next year, but don't want to be on the hook for any unpaid taxes. So they're now pushing back to agencies to say, we don't want the workers to be agency PAYE, we want them now to be umbrella. Because basically what that does is passes the liability down the chain. If the workers are umbrella, as I said, the agency will be on the hook and also the umbrella company, and then that takes the client out of the equation there. I actually had an example yesterday of an agency who were speaking to one of their clients, and the client has a number of workers that they pay directly through an umbrella company. So the end client pays 50 temps or contractors directly through an umbrella company. So in that scenario, the umbrella company and the end client are on the hook for any unpaid taxes as of April 2026. The end client have now asked the agency to take on the payroll responsibility. So the agency is now passing it down the chain. So the agency is responsible for paying these workers, but all the agency is doing is paying them umbrella. So they're basically passing them on to the umbrella company to be paid. So then it's the agency and the umbrella company that's on the hook under the legislation, and that takes the client out of the equation. Now, something I've been in the industry for 20 odd years that I couldn't believe on this. and all the agency are doing is passing it down to the umbrella company for us to do the payroll. Some agencies are charging as much as 5-6% of that for that, just for passing that on to an umbrella company. So there's a potential opportunity for you guys to get close to your clients, have a chat with them that you want to try and help them take away this liability. And effectively, all you're doing is passing the workers on to an umbrella company to get paid, just to mitigate the risk for the end client. If there's a neutral vendor or a master vendor in the chain, that one's quite interesting. In that scenario, even though you get the client, the neutral vendor, the agency, and the payroll company, it's always the sort of top two, if you like, in that chain that will be joint and several liable. I'll be able to say that, put my teeth in. So in that scenario, it will be the neutral vendor or the master vendor that would be liable for any unpaid taxes, and the client. So what we're finding now is that the neutral vendor or the master vendors, again, are trying to bring umbrella companies into the chain there, to ensure that the liability stays away from the client. So again, these are all really interesting conversations that you should be having with your clients, because this will put you on the front foot and make sure that you're ahead of the game of your competitors. So this legislation, as I said before, is effectively trying to get rid of all the sort of bad guys, the non-compliant operators in the payroll industry. The main non-compliant payroll companies are called mini umbrellas. So mini umbrellas has been a massive grey area in the payroll industry for as long as I've known. And effectively what mini umbrellas are, it's where a payroll company sets up lots of mini companies, say hundreds and hundreds of sort of individual companies, and pays the contractors through there. They keep them below the flat rate VAT threshold, and ultimately the agency, they don't have to pay employers NI. So what they'll do is the agency would charge the client for employers NI, but then them and the payroll company would end up keeping that. So yeah, that has been a huge grey area in the legislation. Something that HMRC have promised they're going to crack down on, and this legislation does crack down on it, because what they've done is they've combined this legislation with the Criminal Finances Act, and if anyone, as of April 2026, continues to use a mini umbrella company, they can be punished by up to 2 years in jail. So they get a 2 years custodial sentence if you continue to use a mini umbrella company as of April 2026. Now, it's not just the directors and the owners of the company that can be punished. Anyone in the business, managers, staff, anyone that knows that they are using a mini umbrella company can also be prosecuted. So it's massive. I can't explain enough about how important it is. If you are using a mini umbrella company, you have to stop it. So what do an agency do to protect themselves? The easy way to do it is make sure you work with an umbrella company or a payroll company that's SafeRec or FCSA approved. As I said, AGPayroll, we're already SafeRec certified, and we're basically weeks away from getting FCSA accreditation. If you don't work with a compliant or one of the payroll companies that's got those badges of honour, the accreditations, then that's opening up the door for an HMRC investigation, which nobody wants. So just to give you, again, I'll reiterate, I'm just going to sort of repeat a couple of things here, but they are really important. So I just want to just emphasise the consequences on this, and the change, and the way it is just now, and the way it will change to after April 2026. So the way it sits at the moment, if you're using an umbrella company at the moment, all PAYE and national insurance contributions, the responsibility sits with the umbrella company. Under the new legislation, the responsibility will sit with the umbrella company, but also with the recruitment agency. So again, make sure you use a SafeRec or FCSA accredited umbrella company. With regards to the umbrella company is the employer. So we have to do all the due diligence on the contract of employment, the right to work checks, the share codes, etc. So agencies could always just say, well, that's not our responsibility, it's the umbrella company's responsibility. Agencies have to get proof from the umbrella companies that they are getting all this information, because ultimately if they're not and there's a compliance breach there, then again that liability will sit with the agency as well as the umbrella company. So if you're working with an umbrella company, ask them to take through their processes. So like ourselves, for example, we've got an agency portal. So on our agency portal, we can evidence to our agencies that we're collecting in all the right to work, the share codes, etc. And also through our Safe Rate accreditation, they get a monthly report that shows that all taxes are being paid and that all deductions are being made fully 100% compliantly. So yeah, just ask a lot of questions from your payroll company to make sure they are fully compliant. And in the past, the Employment Agency Standards Inspectorate looked over the payroll and recruitment industry. It wasn't really fit for purpose. Now this new Fair Work Agency is now going to have some power and some resources behind it. So they're the ones that are going to implement any fines or potentially pass it on to be criminal convictions as well. So the risk of using a non-compliant payroll companies, again, I'm repeating myself a wee bit, but it is important to understand this. The top one, which is hopefully going to run the bad guys out of town and get rid of all the many umbrella companies, is the criminal liability. The 2 years imprisonment is huge. And again, it's not just directors and owners, senior managers and various people within the company can be criminally liable as well. There can be legal and financial penalties. Again, there's that joint and several liability for the agency if the payroll company goes bust. There's reputational damage. HMRC publish anyone that's not being fully compliant with the and paying all the taxes, etc., which could lead to loss in PSL positions, losing clients, lots of reputational damage. There could be working impact. The contractors could be left with unexpected tax bills if the payroll company goes bust and the agency can't pay it. Then they could go after the worker for any unpaid taxes as well, which again would be business ending. And there could be lengthy HMRC investigations. Once you sort of open the door to HMRC, then it's a bit of a can of worms. So again, nobody wants that. So the compliance requirements for agencies, there's a shift in liability. You can no longer just outsource the risk. You have to make sure that the companies you're working with are fully compliant, but you have to get under the bonnet with your payroll company. You have to, if HMRC or your client comes to you and say, how do you know you are fully compliant under the new legislation? You can't just say the payroll company deals with it. You have to have evidence. You have to be able to tell them exactly what you're doing and how the payroll company is keeping everyone in the chain fully compliant. And if you're with a Safe Rate accredited umbrella company like AGPayroll, it's easy for that to be evidenced with a monthly report, and there'll be a couple other things that I'll mention later on in the presentation. You have to look at the due diligence. You have to strengthen that due diligence. As I've said, you have to make sure you're looking under the bonnet. You have to review the contracts. There's something that's coming into play recently where agencies are trying to write into the contracts that the payroll companies are solely responsible for any unpaid taxes under the new legislation. That's not going to work. That's not going to fly at all. It's like you can't just change the law and the legislation to suit yourself. It doesn't matter if it's in a contract. The legislation says there has to be two parties, joint and severally liably. So let's try that again. Right, we'll get that in the end. Joint and several liable for any unpaid taxes. So it has to be either the agency and the umbrella company or the agency and the client that's on the hook for those unpaid taxes. So you can't just write it into a contract and say it's not our responsibility, it's the payroll company's responsibility. Make sure you're sharing the communication, or you're making sure you're fully transparent with the workers. If you're not sharing key information documents with workers at the moment, make sure you are going forward. again, we do that as a sort of standard part of our process where we help the agencies with the key information documents and we send them out to the workers, and we also give the agencies a copy of that. Understand the exposure and the liabilities for yourself. So just make sure that again you're fully compliant with this, and make sure you're auditing and you're keeping a hold of any records. Or as I said, with ourselves, for example, you would get a monthly report. So make sure you're keeping these SafeRec monthly reports on file. So if there is any audits, you've got that proof, and you'll be able to tick the boxes from a compliance point of view. So key messages on this for agencies is don't assume compliance is sorted. You can't just assume that the umbrella company's got this in hand. There's too much financial liability, and also, as I touched on, criminal liability if you don't make sure you do your own due diligence on that. So make sure you really do look under the bonnet with your payroll company and make sure they're either FCSA or SafeRec accredited. Again, what a compliant payroll company. We've put together an audit in the last 6 months. We've looked at, together with some industry experts, we've pulled together a sort of 20-minute audit questionnaire, which we're going to launch in January. There's going to be a cost of this. It's going to be £545 plus VAT. But for anybody that's on here today, if you want to try this just now, or if you want to complete it, then we're going to give you it free of charge. Because basically we're trying to trial this with around a dozen agencies before Christmas, because we're a wee bit quieter. Things are going to go a bit crazy in January. So we'll do an umbrella legislation audit, which will involve a questionnaire. Then you'll get a 30-minute consultation with either myself or my sales director, Chris Dwyer. And then at the end of it, you'll get a PDF report, which is bespoke to your recruitment agency. And it gives advice on where you're strong at the moment and where your gaps are with regards to the legislation. So yeah, reach out to me if you want any help on that. And just a bit on AGPayroll. Again, we are SafeRec certified, and what that does, I keep talking about this monthly report. The monthly report that you get says that, so SafeRec integrates with our government gateway. So it says that we have paid all the taxes on time every month. So that makes sure that everything ticks the box from a tax point of view. And it also integrates with our payroll software to ensure that all the deductions are made compliantly. So this report at the end of the month is your peace of mind that basically we've done everything, we've paid all the taxes, and all deductions are made compliantly, and you can use that in an audit. And also that we provide key information documents. We do all the sort of compliance side of things. We do all the due diligence requirements, and we've been in the industry a long time. We've been in the industry sort of over 40 years, so we're experts in what we do. And also, as well as the compliance report, FREC are also introducing an insurance policy. Now, this insurance policy says that any SafeRec accredited umbrella companies and the agencies that they work with, if one of those umbrella companies goes bust and there is a tax liability or any legal fees, the insurance policy will cover all tax liabilities or any legal fees on that. So that really is a silver bullet for this legislation that's coming into play. It gives any agencies peace of mind that you not only get the monthly report, but there's also an insurance policy that backs that up as well. So again, it goes back to what I said at the start. Everyone wants to make sure that they're fully compliant with HMRC so everyone can sleep at night. So this legislation is huge. It's potentially business ending, but also, again, keep going back to these potential criminal liabilities as well. So you have to make sure you get under the bonnet with your payroll companies, ensure that you're dealing with fully compliant umbrella companies. AGPayroll, as I said, we're good to go as of today with our SafeRec certification and the insurance that comes with that. So I'm more than happy to speak to you guys around this. Just to sort of blow a bit of smoke up our backsides, as I said at the start, we won the Contracting Awards 2025 Umbrella Company of the Year last week. I'll just grab the award here. Guys in the office are laughing here. That's the award there. yeah, we're all over the moon. That's just it's just a bit of testament of what we do and the standards we're trying to drive here, because that award's based on everything that I built the business around. It's to do with compliance, technology, and service. So I'll be a bit cheesy here. If you want to work with the best, then work with us. And as I said, the umbrella legislation audit that we've got, I'm happy to give that away free of charge up until Christmas. So reach out to me by email or give me a call. And I've also got a LinkedIn group set up called Recruitment Insights and Trends, and that gives everyone an update on what's happening with the Employment Rights Bill and the umbrella legislation. So thanks for your time, everyone.